Hi, everybody. Welcome to another episode of Rapping with the Rep. I'm State Representative Ken Gordon. Today, we're going to have an interesting talk about sexual harassment in the workplace and in our community, and some of the things that we're doing to address that, and some of the focus that's been placed on it. With me as our guest is Kelly Pappas. Welcome, Kelly.
Thank you for having me, Ken.
Kelly is an attorney, and she is the co-chair of the Government Affairs Committee of the Burlington Area Chamber of Commerce.
Correct.
And in a unique position to talk about these sexual harassment issues that have been in the news recently, and most importantly on social media. There's a Me Too hashtag where I think many victims of sexual harassment that previously had felt embarrassed and unwilling to talk about it have now added strength to other victims by saying, you know what, this isn't as unique and unusual as people may think it is. And where there's safety in numbers, people have been talking about it like never before.
The Me Too hashtag, I think, really sort of took the world by storm. And I think what was surprising to me is that so many people were actually surprised by the number of Me Too hashtags that they started seeing. I actually posted, instead of the Me Too hashtag, how about if all of the people who are being accused or haven't been accused yet started posting an it was me hashtag, because you're forcing the women and the people who have been harassed really to relive what happened to them with the Me Too hashtag. But it definitely brought some awareness to this issue.
Yes, and some of you may know that my career outside of the legislature for the last 17 years, 17 of the 27 I've been an attorney, has been representing victims of sexual harassment, discrimination, and wrongful termination in the workplace, as well as sometimes the companies. So I've seen it from both sides and devoted a lot of my practice to it, a lot of my professional attention to it. And this is an issue that has not gone away. It's just now we're talking about it. What we see now has been there all along. And so I think it's important to bring these issues out in the light so that we can really examine why it is that so many people, women, but to some extent men as well, have been the victims of sexual harassment and discrimination in the workplace. How has it gone on for so almost commonly as a culture?
It's not new, unfortunately. It's not new. It's getting publicized now, and I think part of the reason that it's getting publicized is because obviously the people who we're seeing who are being named as harassers are public people. They're Hollywood, they're politicians, they're well-known people.
Right, celebrities with power. And power is the key to all of this.
Absolutely.
It's really not about sex.
No.
It's about power and authority. And that's why supervisor and subordinate, that relationship adds a different dimension to a relationship between two people, and you can never escape that. You've got to remember, people have to remember when they're acting in that way, that one person has authority over the other. So the idea of asking someone out for a date who is the subordinate of the person, that's a whole different situation.
Absolutely.
And that's why under Massachusetts law, we have laws about sexual harassment dealing with verbal harassment as well as touching harassment, or what we call quid pro quo, meaning if you do this, then you'll get a promotion or keep your job or something. We have laws about that wouldn't necessarily apply in a social setting.
Right.
Because people have a right to work in a harassment-free work environment.
One of the laws that I would actually like to ask you about is confidentiality in harassment settlements. So I understand that if somebody settles a harassment claim, they're required to sign a confidentiality agreement, which means the person who is being accused, when they settle a claim, there's no way for anybody else to know that this person has been accused of sexual harassment. What are we doing in Massachusetts to address this?
Well, a couple of things. First off, it's common that confidentiality provisions are included in a resolution of a sexual harassment claim because the person and the company who are being harassed, what motivates them to enter the settlement is to protect their reputation. That's what essentially they're getting out of it. Oftentimes insurance proceeds are used, insurance money is used to pay the person. So it's this reputational damage that is what brings them forward. And for the person who's been harassed, they're suffering emotionally to, oftentimes to a very great extent. So they're looking for a way to cover the expenses that have been incurred. Plus, a lot of times they've lost their job.
Right.
So they have to replace the income that they've lost. So the issue of confidentiality is a right now that a victim, oftentimes a woman, has. She has a First Amendment right. She can speak out. She can talk about what happened to her. But in an arrangement to settle a case, she can also negotiate to give up that right. That protects her. If the victim is a female, that protects her. And so there is a move afoot in Massachusetts and in other states to try to restrict the authority that people would have to give confidentiality agreements in settlement. I'm concerned about that because I think what that does is it tells the victim, you know what, we don't entirely trust you to be able to make the right decision about confidentiality. It might be that someday you regret this and you want to talk about it, but on this day you signed the agreement and took money. Without money, it's not enforceable. You don't get anything for it.
Right.
You might regret and think, well, I didn't get enough money. But the issue is in our society, we trust the two people who are engaged in a contract that they can look out for their own interests, do the best that they can for themselves. So I would tread really lightly on taking away the right of a victim of harassment to be able to do that. The practical effect, if we were to do that, would be this. It's difficult to win at trial. I've tried these cases, I've done this. The problem is that witnesses, if there are any, to sexual harassment usually still work for the employer. And oftentimes, they're very loath to provide testimony that's going to harm them in the workplace. Even though we have laws to protect retaliation, people are still afraid of that. And so the victims don't often get a lot of assistance from witnesses and in the workplace. It's very difficult, therefore, the percentage of successful trials for victims is very low. So the reason that companies settle this isn't necessarily because they think the odds are stacked against them at trial. It's, again, because their reputation will be damaged even if they win the trial. So if we take away a victim's ability to negotiate with confidentiality, we're going to force more trials. That's expensive for the trial court system.
Right.
But really, what we're going to do is we're going to inhibit the opportunity of victims to come forward with their claims because the resolution will be beyond their reach. So I think that's difficult. The other thing I can tell you is that claims that are brought in Massachusetts go before an agency called the Massachusetts Commission Against Discrimination, or MCAD or MCAT. The files at the MCAD are public. Anyone can go and ask if there's a file against a particular person and get it. The only thing that's not automatically a public record would be the settlement agreement. So you wouldn't know the amount that it was settled for. And like you said, oftentimes the parties to the agreement are bound to say, well, we settled it to our mutual satisfaction. But the MCAD has the discretion in certain instances to release that. So I'm preparing a bill that I intend to file hopefully this week that won't affect confidentiality between two private people, because again, I think that we've got to give the authority for people to negotiate about this. But what I want to do is expand the authority of the Attorney General. See, the Attorney General can also file a claim against someone who is alleged to be engaged in harassment, along with the victim. They both have 300 days to bring their suit to the MCAD, and then they can bring it to trial court after that. What this bill would say is that anytime a victim of harassment files a suit, the Attorney General has authority to get involved in that suit, whether the AG brought that case in the first instance or not. They can jump in. They can even jump in if the suit was already settled. It's just that the victim won't get paid more. But if they think that society would benefit from them looking into the matter, they can now do that. And the instances I think that would happen would be if someone has been a repeat offender before the MCAD.
Right.
And they say, we now have this interest. So the second part of the bill says that when someone when the MCAD has issued a finding against a harasser, they call it a finding of probable cause, more than once within 10 years, then the MCAD will inform the Attorney General automatically about that instance, so that the Attorney General now can decide whether they want to pursue this case to protect our society. Again, they're not, the victim of, the alleged victim will have their own lawyer or can proceed on their own, but they'll proceed together in that way.
Well, that would certainly help with the habitual harassers who, up until this point, I think have been able to continue to harass with the confidentiality agreements in place.
Right. See, the thing with confidentiality agreement is, I think most times, if someone is accused of harassment and they settle the claim and they get confidentiality, they've learned their lesson. They never want to go through that again. And so I think the vast majority of these cases, therefore, you've taken the harasser, you've taken that behavior away from that harasser, and then society, has less of a concern. The person's not doing it again. The problem is the Harvey Weinstein instance, where someone says, this person's done this 10, 20 times for years and years, and nobody knows about it. Those kind of cases, if they occurred in Massachusetts, would get to the Attorney General. The Attorney General is not bound to any confidentiality. They can issue whatever statement they want, and when they resolve cases, they do it in a public way. They issue a press release. So it gives that harasser another thing to worry about now. If they get involved with this again, they're going to get before the AG, and whether they received confidentiality in that first instance or not, the AG is free to talk about what happened here. So I think, therefore, without interfering with the rights of the victim, we can maybe get close to that goal there.
You mentioned Harvey Weinstein. We have Harvey Weinstein. We have Roy Moore. We have Al Franken now.
Right.
Years ago, we had Bill Clinton. And what I've seen is certain demographics, certain political groups supporting, let's say, Roy Moore, and then calling for Al Franken to step down. Do you think that we are, as a culture, targeting specific individuals? Are we following party lines as we call for certain people to step down, but then we're supporting other people?
Right. I think in so many different ways in 2017, we're polarized by our party identity. And it would be interesting if we were to watch, TV commentators, and they're told about conduct of a particular government leader, and they're not told what party or what the name. They just say this is a generic person in Congress, and this is what they did. Now comment on that. And then afterwards, they're told what party they belong to, and they might be surprised.
A blind test.
Blind test, because what we do is it's as if people have uniforms, and there's no, we're in our silos. So the reality is there is no reason for a government leader to be touching women.
Absolutely.
If they're men, there's just no reason for it. And to say that, well, it was misinterpreted or something like that, no. You don't have to do that. You don't have to put your hands on people to take a picture. Oftentimes we get in close, and I tend to do it. I'm a state rep. I'm not a U.S. senator. So U.S. senators have even more experience with this. But I'll put my arm behind the person because you're close enough for the photographer. But there's no reason. And it doesn't take much to sort of figure that out. There's no good could come of sort of a fake familiarity, because if it's a person you don't really know, I don't know the message that you're really giving for the purpose of the photograph, really.
Right.
If it's a person you do know, then it may be welcome. Then you would have what we call consent, and that's fine. So, party lines should not be drawn. If a person is the type of person who cannot show enough respect for a fellow citizen or a fellow person, that is, to be able to keep their hands off that person, to be able to keep from saying vulgar things about that person, then we need to decide, is that person fit to be a leader in our government, a leader in our society, irregardless of party.
And I hope that that's one thing that will come out of all of the publicity regarding what's going on now. It's not okay, regardless of who you are, regardless of your political aspirations or your political position. Unwanted touching, harassing, it's not okay. It's not acceptable.
No, And you know what else we see is the idea that you just attack the reputation of the victim who's now come forward, especially after a long period of time. That victim has no reason to come forward.
Right.
None at all. And to do that, what you're doing is you're showing the message to the person who's only been accused once, who's not a celebrity, that, you know what, it's okay, here's my strategy. I'm coming out guns blazing to attack the reputation of this person. And what you're going to do is, again, put victims back into, a corner where they'll never emerge, because that's the reason why victims don't come forward.
And legally speaking, the onus is really on the harasser to prove that it didn't occur. When somebody comes out, it's culturally what we're doing, we're blaming the victim. In my opinion, there's a lot of blaming the victim. But legally speaking, the victim does not have to prove that it happened. Correct?
Well, under our litigation law, strategy, in a court of law, the plaintiff, the person who wants damages, who says I've been harmed and I want money, yeah, they have the burden of proof. But in society, we don't have those same rules. And I think that what you're saying is, in society, if someone comes forward, in fact, more than one person who haven't met each other, different period of time, different place, logically speaking, again, there's no reason for them to be making something up. There's no reason for them to be put under that microscope. So I think in the court of public opinion or in society, yeah, I think at that point, it's not up to them now to have to prove every little thing, because now you've got sort of corroboration. And again, we lead by example in government and some celebrities, and we are role models, whether we like it or not. And so the message that we convey to other people in society has to be, act as I do. We've got to hold ourselves up as an example. So are we fit to lead if we don't set the right example and the right tone in this society? No matter whether you wear a D or an R on your back, it's the same thing. There are certainly different levels of a sexual harassment situation, and we know that. I mean, we can see that. But there's just, there's just no excuse.
You talk about setting the tone for society, and I believe, just as in a business, it starts from the top down.
Right.
So in D.C., if somebody were to accuse somebody in Congress of harassment, they have a cooling off period. They are required, I believe it's 1 month of counseling before they can bring a suit against the congressperson who they're accusing of harassment. And even if it's settled, it's the taxpayers who are paying that settlement, not the congressperson. How is that handled in Massachusetts?
Well, first of all, I hope that changes in the U.S. Congress. There's been a bill filed, and I know that our Congressman, Seth Moulton, has co-sponsored it, and I'm glad that he did. I'm proud of him for doing that, and I certainly hope that changes quickly. So we have a sexual harassment policy, and it's distributed to our staff when they come in. But we're looking at that too, because really these need to be reevaluated. No, we don't have a cooling off period, and that I know of, public money has never been used to settle a harassment case, and I've asked around to see. But we can do better. Many of our rules they're just old, and so they're technologically old, which means they're just behind the times. For example, one of our rules requires someone who feels that they're a victim of sexual harassment to physically go somewhere and report it to HR, right? Well, why? Why do you have to walk past people in order to walk into an office to report something that may be very embarrassing to you and maybe about a supervisor that inherently people are going to start off trusting, and now you've got to say, I know this person makes a lot of money for you and is very important in this business, but this is what this person has done, right? So there should be an online mechanism to do that, so you don't have to take that step. It's a difficult step for somebody to take. Or a telephone line with a recorded message, and then someone calls back. And it's someone that's outside of the organization. So you, again, establish that level of trust that this person can now advocate for you once you demonstrate a story that, is a credible story. And these are all things that we're looking at now. In a large, and the other thing about a legislature is we're elected to the legislature. So we have to handle it a little differently than a private company, because we'd all, I report to the voters here in the 21st Middlesex District in Burlington, Bedford, and Wilmington, not to the Speaker of the House, for example. So the discipline as to a member is a little different than a private company, but we can handle that. We can handle it. We do have a policy that we're working on right now to update our policies. I'm helping to do that. It'll either turn out to be a piece of legislation, or it could be just internal rules, because how we conduct ourselves, we vote on as a rule. But we can handle these things, and we've got to. Again, we've got to lead by example.
Our own state house is not immune to allegations, unfortunately. And over the past few months, there have been allegations surfacing about things that have been happening in the State House regarding harassment. Have you seen a change at all in the way things are being handled, and the just actions between people since these allegations have come forward?
Well, there's a conversation that's going on in the State House that we never had before. I mean, this is an important issue to address. I haven't seen personally many changes, because I was not close to these types of things. They didn't happen before me. However, the news came out before anyone was talking about the Massachusetts State House. There was a story about the California legislature, and also a state senator in Rhode Island complained about how they were treated. So immediately I asked my staff member, and then some staff members who we shared some office space with, together with a representative named Paul Schmidt, who we were neighbors, suite mates. So we asked, have you ever seen anything, or experienced anything? And we were told no, but there was a feeling of not sexual harassment, but discrimination. It's a different way to look at it, which was to say, you know what, some of the people who come into the State House to explain their programs and their priorities overlook women in a staff position to a much greater extent than they overlook men. And that's troubling too.
Absolutely.
I'd like to work on that, but that's an attitude that largely people from outside of the State House bring in with them. And I know that's cultural. As you said, this has been going on for a long time. It's been going on since women in larger measure came into the workforce.
Right.
Men didn't know how to handle it. Their authority was being challenged, their positions, they just didn't know how to handle it. And so we crafted laws here in Massachusetts. I have a bill, by the way, that I filed a few sessions now, and I think it's got some real traction, that will prevent companies from forcing employees when they first get to the job from waiving away important rights. And one of the important rights that workers commonly have to waive is the right to have Massachusetts law apply to their situation. It says, if I ever have a dispute at my work, I agree to arbitration, and I agree that because you have an office, say, in Delaware, or you're incorporated in Delaware, where those laws are more favorable to that employer, they say the laws of Delaware will apply. Sometimes they even say you have to bring your case there, which means a lot of people who just lost their job will never bring their case, right? Well, so if the laws of Delaware apply, or Utah, or anywhere else, all the employment protections that we vote on in the legislature for Massachusetts workers just don't apply to that situation. So my bill says that if you want to come to Massachusetts and hire a Massachusetts worker, then Massachusetts law applies, and Massachusetts courts are here to figure out the dispute. That will help, because we do have strong sexual harassment laws here in Massachusetts, and a strong commission against discrimination, and a strong attorney general. Another issue that I think a lot of victims of harassment face is that you have to bring these cases with lightning speed. In Massachusetts, you have to bring them within 300 days. If you hit somebody in your car and they hurt their back, that's 3 years you have to bring them. So you get to wait to see how much I have in doctor bills. How hurt did I really get? Well, sometimes when someone has been sexually harassed or discriminated against, the emotional damage that occurs, they don't realize right away. Yeah, I'm grouchy, but maybe I'm kind of grouchy anyway. My husband, my wife, they're complaining, my kids. It may be a couple of years later where you realize, you know what? I didn't really act this way before I was treated with such disrespect, because I was so humiliated and so degraded that what started out as anger has turned out to be really something that's formed a depression or anxiety condition for me that I really do need.
And that can take years to manifest.
Right.
And I think that if somebody's actually living through it, if this is all they've known, if they've been in the same position for a long time, let's say, and this is the culture of the company or the person that they work with, they may not even know that what's going on.
Oh,
it may
yeah.
be a subtle, it may not be a complete affront of harassment, but it may be an ongoing subtle harassment that they don't even recognize it
Oftentimes,
until
yes.
later.
Oh, you're so right. Oftentimes, even the conduct itself, because it may be a job that someone started when they were very young. And it's only when they talk to someone from outside the work site that, that someone says, hey, they can't treat you that way.
Right.
They can't do that. And that happens more often than not. And if this conduct hasn't occurred for a while at that point, then there's nothing that can be done to help that person. And so, this is, again, it's a sea change of attention, which allows people the safety in numbers to come forward and say, this stuff has happened. And so if it's happening to you, it's more likely that you'll be believed. Do you think that, we have issues that come about and they get a lot of attention and then they kind of go back into the conversations that we might have? And do you think that this is a fad, or do you think that we really are on the precipice of a real change in our attitude toward women in the workplace? What do you think?
I think this is here to stay, and I think it's about time. I think that women are finding their voice. I think that there are probably a lot of men, and again, I understand that it happens in women can certainly harass men, but the majority that we see is men harassing women. I think that there are a lot of men out there right now who are going to work every morning scared that are they going to be the next one named?
Right.
So I don't think it's a fad.
Right.
I think that it's a new wave of this is unacceptable. We're not going to be quiet about it anymore, and it needs to be fixed. We need to be heard. It needs to be resolved. The culture needs to change.
You bring up a couple of great points. First of all, if men have been engaged in this type of behavior in the past, confident that they won't get caught because no one's really going to turn them in, now, like you say, they go to work every day wondering, is this the day that somebody
Yes.
writes the Me Too on their social media or in another way? And I've got to face things that I've done in the past. And am I going to act responsibly if that happens and address it, or am I going to attack the person?
Right.
And the other thing is, it's not just, it is directly a women's issue because proportionally speaking, like you said, more women find themselves victim, but also the men who have been enablers, who knew of instances where things happen and looked the other way. Now they've got to wonder, what have I done? What if it should never be this way, but what if it was my relative?
Right.
Would I have looked the other way? That shouldn't be the test, right? You should, but is that, that's something we've got to address too. And now, is it, with safety and numbers coming about, easier for the witnesses to now come forward and say, no, we can't do this?
I think you make a really good point about enabling the situation. Men who have stood on the sidelines, and women who have
True.
stood on the sidelines and witnessed it, yet not come forward. I think this is definitely giving them the opportunity to say, stop.
Now, you talk to, through the Chamber of Commerce and your practice, you talk to a lot of employers and employees. Do you notice a difference in the conversation, or have you seen a difference in the behavior?
So, yes, I'm a lawyer. I don't practice law anymore. I'm actually in the insurance world now, and I will tell you that the employers they're protecting themselves with insurance. They know that we don't have that culture, but I can't see every one of my employees every single day. They're protecting themselves with employment practices liability insurance. So it's definitely, they are more aware of what's going on and asking me for the employee manuals and sexual harassment training. So they're definitely more aware of what's going on now.
Is there a discussion, either through the chamber or otherwise, about access to mandatory sexual harassment training with a greater attention than was before?
There is actually. We just had a sort of an offshoot discussion from the Women in Business meeting the other day. We had a discussion about bringing this up as one of the upcoming topics at our Women in Business meeting, talking about sexual harassment in the workplace, how to recognize it, what to do if you witness it, what to do if you're a victim, and how to deal with somebody if they're a harasser. So it's definitely something that we're talking about in the chamber. Yes.
Well, that's very important, and if you need help or if you need some input, I'd love to be there for
Absolutely.
you. Kelly Pappas, thank you very much for being our guest here on Rapping with the Rep. It was a fascinating discussion. Thank you for making it better. Thank you, everybody, for tuning in, and we'll see you next time here on Rapping with the Rep.